Hello, everyone, and welcome to Uncivil Law. For today's case, we have a story of what constitutes unlawful disturbance, what constitutes improper disturbance, and whether or not you really have to identify yourself to the police. This is the case of City of Las Cruces versus Osvaldo Flores. In this case, Flores was asked to identify himself to the police, and he didn't want to. The police arrested him for disorderly conduct because, of course, they did. The question is, are the police allowed to do that? Let's get started with this. Defendant appeals from his convictions following a de novo bench trial in the district court of 2 counts of resisting, evading, or obstructing an officer, contrary to Las Cruces Municipal Code Ordinance of New Mexico, and 1 count of concealing an identity, contrary to law. Defendant argues the evidence was insufficient to support his conviction because the arresting officers were without legal authority to detain him for questioning or require him to produce identification. Okay, so this comes down to the ever-popular topic of, do you have to identify yourself to the police? And if so, under what circumstances? Now, before we press on, I would be remiss if I did not point out that this is going to be, in large part, a feature of state law. So various states have different laws when it comes to when you do or do not need to identify yourself. So before you take this case and run off completely off the end of the page, take note that this is going to, at least in part, to turn on specifically how New Mexico writes its specific law. And so as to other states, your mileage may or may not vary. But we'll try to learn some lessons that will apply in other states. So at least as far as New Mexico is concerned, did he have to identify himself? And if so, why? Let's read on. The defendant was charged under the law for offenses of evading an officer and concealing identity. Following conversation with a neighbor, an officer approached the defendant, who was standing with another officer, and asked him for his identification. So the police were here for reasons unrelated to the defendant initially, and they were interviewing this neighbor for whatever, and now they want to talk to the defendant, who is otherwise uninvolved in this interaction, and ask him for ID. Defendant turned his phone towards the approaching officer, held up his other hand in gesture to stop, and told the officer step back. This is where the auditor crowd, I'm sure, gets really thrilled. He's like, I don't have to identify myself. Let me film you. The auditor crowds are thrilled with his behavior. As the officer continued to approach, defendant said, "Stay away from me." The officer told the defendant, "If you keep yelling and you keep screaming and you keep causing people to come outside, you'll be arrested for disorderly conduct. Contempt of cop. May not actually be a thing, though." The officers repeatedly demand defendant produce identification. Defendant responded, "I don't need to identify myself to you because I've not committed a crime." Is he right? Well, following a bench trial, the defendant was convicted of 2 counts of resisting, evading, or obstructing the officer, and 1 count of concealing the identity. Defendant now appeals. All right, so all of our the auditor friends should be thoroughly thrilled with this case and trying to figure out whether or not this guy has the right to refuse ID. So the police are coming for reasons unrelated to the defendant. The defendant is essentially a looky-loo. The officers, after doing whatever they were there to do, come ask this guy for ID, and he's like, "I don't want to, though." And then he starts filming them, and the officers say, "If you keep yelling and screaming, I'm going to arrest you for disorderly conduct." And then they arrested him for disorderly conduct. So did he have to identify himself? Was he disturbing the peace? Let's find out. The defendant argues the evidence was insufficient to support his convictions because the officer lacked reasonable suspicion to detain him and require him to produce identification. And this will please the auditor friends. We agree there was insufficient evidence to convict defendant of the charges. The right to go about your business is restored, at least in New Mexico. Yay. Defendant argues that reasonable suspicion is an element of the charge against him, and therefore our analysis of sufficiency of evidence must entail whether the officers had reasonable suspicion to detain him. Yes, so whether or not you can detain someone is going to be influenced by probable cause. So we have what's called a Terry stop, where we can maybe frisk you for weapons and things that are a danger to us. But if we want to actually detain you, we have probable cause standards. So, and especially if we're going to conduct an arrest, because an arrest can only be made with probable cause, whatever Terry might hold. So did we have probable cause of any crime in order to detain and arrest him and ultimately convict him of his contempt of cop? Defendant argues that reasonable suspicion is an element of the charges against him, and therefore our analysis of sufficiency must entail whether the officers had reasonable suspicion to detain. Whether evidence is sufficient to support a verdict requires inquiry into whether direct or circumstantial evidence exists to support a verdict of guilt beyond a reasonable doubt with respect to every element to a conviction. So, as is true, as always, the government needs probable cause, and they need to be able to get ultimately to beyond a reasonable doubt for each and every element of the charge. If they're missing one, it doesn't count. You need them all. All right? The elements of the charge for evading an officer and concealing identity are identical to the state law counterparts differing in penalty. So there was some city level charges in Las Cruces, the municipal code. In the municipal code, there are charges. He was charged under the city's municipal code. And the government the court is pointing out, it's exactly the same as the state law counterpart. It differs only in the penalty. So we can analyze them both equally well. So he was arrested under the city ordinance that they actually paid attention to, but it says, it doesn't matter. You could have done the state one. It's the exact same thing. Only difference is the penalty. Like its state statute counterpart, one of the essential elements of the Las Cruces Municipal Code crime for evading an officer is that the person committed the act of evasion has knowledge that the officer is attempting to apprehend or arrest him. Our Supreme Court has stated the definition of apprehend means seizure in the name of law, and equated such an apprehension to include a situation in which an officer is attempting to briefly detain a person for questioning, and this is the key part again, based on reasonable suspicion, because at that point, if you're thinking reasonably articulable suspicion, you're thinking about a Terry stop as opposed to probable cause. So again, this is one of these things where these words mean different, or these words matter. So when the court says the situation includes reasonable suspicion, they're thinking Terry stop. So apprehend includes a seizure and also includes a Terry stop. Okay. Further, like the state statute, one of the elements of concealing identity pursuant to the municipal code requires proof that the officer is acting in a legal performance of his duty. So this is one of the key elements that is going to come at charge. So you have to be evading the officer, even from a Terry stop. But in order for a Terry stop to exist, the officer has to be acting lawfully. Now, reasonable suspicion isn't very much. Reasonable articulable suspicion is a pretty low standard indeed. But still, it's something. And if you don't have that, you can't even conduct a Terry stop. So you can't be evading an arrest or a stop that wasn't lawful, at least as far as New Mexico is concerned. Again, your mileage may vary in other states, but at least in New Mexico, if they weren't able to arrest you, you can't be evading the arrest. So, nice to know in New Mexico, at least. Accordingly, to assess the sufficiency of the evidence for the crimes of evading an officer and concealing identity, we must address whether evidence at trial established the existence of reasonable suspicion, that would be like a Terry stop, giving the officers the legal authority to detain the defendant for the purposes of the Terry stop. All right, so what is reasonable suspicion? Reasonable suspicion exists where an officer can point to specific articulable facts. Yeah, reasonable articulable suspicion is the way it's sometimes phrased because of exactly this reason. It has to be articulable, specific, together with rational inferences that when judged objectively, so not from the point of view of this particular officer, but from the point of a reasonable officer, the reasonable man test. The reasonable man would have specific facts that, together with rational inferences, would lead the person to believe a criminal activity was occurring. So you have to have some evidence of some facts and some inferences that would lead you to believe some crime is occurring. It's a pretty low standard, but as we're about to find out, the courts or the cops in this situation were unable to meet even that low standard because they were just harassing the guy. The district court, apparently without regard to the neighbor's testimony, concluded the officers had reasonable suspicion to investigate disorderly conduct based on the fact that defendants had loudly criticized the police. The district court went full on, we can arrest you for contempt of cop. The Court of Appeals has some thoughts. Disorderly conduct, the Court of Appeals would like to remind you, constitutes the following: engaging in violent, abusive, profane, boisterous, unreasonably loud, or otherwise disorderly conduct which tend to disturb the peace, which is going to be context dependent in this situation and many. So what will disturb the peace in one situation may not disturb the peace in all situations. So like all good things, and all good things in law in particular, it has to be determined by the facts. So it is probably notable and important that this is happening outside of people's homes in the middle of the day. So this is happening on the street. in the middle of the day. So what counts for unreasonably loud or boisterous or even profane content will differ based on context. So if this was happening, say, in the middle of a Starbucks, or in the middle of a business establishment, or if it was happening at night when people are trying to sleep, or in some other situation, the legal analysis might change. But because the facts change. So what we have to look for is what is inappropriate for this circumstance, not necessarily all circumstances. Conduct is not criminal, not even suspicious, because it is boisterous or unreasonably loud. The conduct must also tend to disturb the peace. You must actually disturb the peace. So again, what works in the middle of the day on the street is going to be a little bit different than what is true in a Starbucks or late at night. So like all good things, it's going to depend on context. If you're not disturbing the peace, which in the middle of the day is going to be a lot harder, it's not a crime. This is particularly true when the conduct at issue is comprised of only words, because First Amendment. New Mexico courts have criminalized only limited classes of speech, such as the lewd and obscene, the profane, the libelous, insulting or fighting words, those of which the very utterance inflict injury or tend to incite an immediate breach of peace. So, yeah, you need to actually disturb the peace to disturb the peace. Deep concepts at work. In its ruling that the defendant's conduct towards the officers provided a reasonable suspicion to investigate disorderly conduct, the district court explained. So this is what the district court thought. Let's read what the district court had to say about this. You're not allowed to be so boisterous and so loud to police officers, and accusing and threatening. I think that was disorderly conduct. When the police officers approach us and want to investigate something, it's yes or no, sir, or someone can end up dead. If you contempt the cop, they might shoot you. That's good news. When a police officer approaches you and asks for ID, you give it to them. That's the way it goes. It's not the way it goes, as a matter of fact. Read your law better. Now, if you're just standing on the street, I guess, and doing absolutely nothing, which is not your situation, which it was, I suppose you legally have the right not to give your ID, which, being a court should be kind of important to you. But then you're probably making a judgment call you need to let a judge make. No, you don't. If you're within your legal rights, you can just invoke them. What? No. Try again, district court. Try harder. Try the law better. Contrary to the district court's reasoning, our Supreme Court, which they mean the New Mexico Supreme Court here, by the way, the state Supreme Court, and this court have applied the rule that in most instances, arguing with a police officer, even when using profane and insulting words, will not be enough to constitute disorderly conduct unless the words are also coupled with threatening behavior. You need a little bit more than merely saying mean words to the police for there to be a breach of peace, yes. Police officers, by nature of their training, are generally expected to have a higher tolerance for offensive conduct and language. So maybe you shouldn't be just a wilting wallflower because, you're used to being a hardened, battle-tested police officer. So maybe some mere mean words should not be enough for you. It is because of their degree of skill, training, and expertise we rely on these officers, not only to complete their duties, but not to react to these verbal provocations at the risk of escalating a situation rife with conflict. We actually do expect a little bit more from our fellow police officers. We next address the city's argument that even in absence of reasonable suspicion to investigate disorderly conduct, defendants' repeated refusal to produce identification or, following this refusal, to respond to officers' commands not to walk away, which he didn't have to do because he had no reason to walk away. He was where he had the right to be. So you can't order him to disperse. There wasn't like a riot in place or some sort of mass disturbance that would require you to order him to leave. He was presumably outside his house because it was his neighbor, and he had the right to be there, and you can't order him to leave. Leave to where? It's his house. Anyways, to respond to not to walk away. While the city is correct that officers do not need justification to approach a person and ask a person questions, true, an officer can walk up to anyone and ask questions because anyone can walk up to anyone and ask questions. But this is true only as long as the person remains free to leave and is not required to ask questions. Yes, if the police want to take advantage of the fact that they can voluntarily ask people's questions as their right, which anyone can go up to anyone and ask questions. So, but you know what makes it not voluntary? when they're required to answer them, or they're not free to leave. Then it's not so much voluntary anymore. And the defendant who flees a seizure that is unsupported by reasonable suspicion cannot be punished for exercising his right to end the encounter and walk away. Again, your mileage may vary in other states, but at least in New Mexico, if you want to walk away, which incidentally, he was ordered to disperse, so walking away would be what they told him to do, which is also odd, but you can't be arrested for fleeing a reasonable, articulable stop that didn't exist because you never had the stop in the first place, at least in New Mexico. Try again, district court. Try again to law harder. Even though you have the legal right, was kind of where you were supposed to stop that analysis, district court. Yeah. Lastly, to the extent the city argues it was reasonable for officers to detain an individual to investigate his yelling and whether he was disturbing the tranquility of the community, we disagree. The evidence does not support a conclusion that it was reasonable for officers to investigate defendant's conduct as tending to cause consternation and alarm. While the testimony established that a neighbor came out of his house during the encounter between the officers and defendant, so a neighbor came out to look, so that makes this a public disturbance. Defendant was not the reason the neighbor came outside. The officer's testimony did not articulate any objective facts, which would establish the defendant's conduct tended to disturb the peace. Indeed, the record is void of any evidence the defendant's yelling and cell phone recording annoyed or bothered anyone else other than the officers. The officers are not able to be sad for being annoyed. The officers have to suck it up at being annoyed. If other people are being annoyed, that might a disturbance of the peace make. If you're annoyed, officers, well, I don't know what to tell you. Suck it up. Try harder. Try to have a little bit more grit and determination. And district court, try to law harder. It was legal, though, was kind of where you were supposed to stop. Yeah. The evidence presented at trial was insufficient to support defendant's conviction, and therefore, we reverse the conviction, remand for entry of an amended order vacating his conviction with prejudice, and we do not permit a retrial in this case. Go away. Just go away forever. It is so ordered. Thus, that brings us to the end of the case of City of Las Cruces versus Osvaldo Flores from the Court of Appeals in New Mexico. In this case, we learned that Osvaldo Flores was doing his watching the watchers routine and auditing the auditors routine. And he was out and about observing the police do their thing. And the police said, how about some ID? And he said, how about no? And then there was some words exchanged, and he got a little bit elevated in his voice. And a neighbor might have come out and looked and said, aha, we're arresting you for disturbing the police. And the district court said, well, you might have the legal right to do it, but, you shouldn't have done that. And the Court of Appeals said, yeah, you have the legal right to do it is kind of where that stops, district court. I don't know what to tell you. They don't have to present ID, at least in New Mexico, or identify himself. And you couldn't do a Terry stop because you didn't have reasonable articulable suspicion that he was committing any crime. He was standing there observing when you came up to ask him for ID. And he's like, no. And you're like, but I have suspicion. Suspicion of what exactly? Standing on my yard. Suspicion that you're not complying with the officer. Let's arrest you for being very bad. And the Court of Appeals of New Mexico says, yeah, no, he doesn't have to present ID. He's allowed to say mean things to the police. You might want to get a little bit more resilience, at least for the moment. That brings us to the end of the coverage of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.